All right. Now, first of all, let me set the stage on this one. There's a gray area in the Supreme Court's decision on Dobbs, going back to justify it with a decision by our state Supreme Court. Was it 1998, Aaron?
That's right. That's right.
In the pro-life versus Fordyce. So explain the gray area before we march and just set the playing field here.
Yeah, so, I mean, a lot of people don't really realize that we have this weird situation in Mississippi where abortion is technically illegal and a constitutional right at the same time, and I know that really doesn't make a lot of sense, but you have to remember in the Dobbs case, the U.S. Supreme Court held that the United States Constitution does not protect a right to an abortion. But we have an opinion from the Mississippi Supreme Court still on the books here in Mississippi called the Fordyce opinion from 1998, like you said. And it holds that abortion is a constitutional right protected by the Mississippi Constitution. And that opinion has not been overruled as of now.
We got a break coming up here, so we'll take the next half hour to do this.
Absolutely.
Could that have been taken care of in a special session with the legislature?
No, this is something that the courts will have to handle.
I got you. All right. Back with Aaron Rice, Director, Mississippi Justice Institute. We'll give it to you in plain, simple terms. If he can't do it, nobody. Justice Institute. And you were explaining again the juxtaposition between the constitutionality from one court to the other, and I'll let you continue, sir.
Yeah, absolutely. I mean, you can think about this as exactly the same situation that happened in the Dobbs case, except on the state level instead of the federal level. So in Dobbs, you had federal courts had taken control of abortion policy and declared that abortion was a constitutional right under the federal constitution, and Mississippi and our Attorney General worked to get that overturned, and they overturned that judicial activism at the federal level. Mm-hmm. But there is still judicial activism at the state level that still exists and has not been overruled, and that's the case called Pro-Choice Mississippi versus Fordyce that says that abortion is a state constitutional right, not a federal constitutional right, a state constitutional right. And so that opinion is still on the books. We have a elective abortion ban in Mississippi now. It's commonly referred to as a trigger law. So after Dobbs overruled Roe, Mississippi enacted a ban on elective abortions in the state, but we still have a Mississippi Supreme Court opinion that says abortion is a state constitutional right. And so our case is seeking to do exactly what was done in Dobbs, but do it here at the state level in that judicial activism, get the courts out of abortion policy, and allow the people of Mississippi, through their elected representatives, to set abortion policy in the state of Mississippi.
Is it a no-brainer, a cut-and-dried situation, or could there be some unexpected decisions from the state Supreme Court?
We are very confident that the court will overrule its case in Fordyce and just really correct its error in Fordyce when given the opportunity. One reason for that, Paul, is that the Mississippi Supreme Court, when it's interpreting the state constitution, can do that however it sees fit. But in the Fordyce case, the Mississippi Supreme Court relied almost exclusively on federal cases, and those, you're very familiar with them. It was the Roe case and the Casey case, and they looked at those, and they, like I said, almost exclusively adopted the reasoning and adopted the cases really into Mississippi Supreme Court rulings. And so now that those have been overruled and called egregiously wrong by the U.S. Supreme Court, we think it's time for the Mississippi Supreme Court to recognize that it made an error there.
So in this particular case, the Dobbs case weighs into the decision from the state Supreme Court.
Absolutely, especially given that the Mississippi Supreme Court based so much of its opinion on federal jurisprudence. Absolutely.
It doesn't change the statutes that we have as far as rape or mother or any of the language itself.
No, and in fact, I mean, what we're attempting to do here is to allow that statute to be enforced and to get a declaration that it is in fact valid and it does not violate the Mississippi Constitution. It's an interesting story, too. I mean, how we got here. One of the reasons that our client brought this case, they're the American Association of Pro-Life Obstetricians and Gynecologists. And, there are groups that oversee them. There are professional medical societies that have just been pushing a pro-abortion agenda for years and years and years. And one of the things they've done is pass ethical guidelines that state that OBGYNs have an ethical duty to provide lawful abortions, and that if they don't provide those, or at least refer a patient to somebody who will provide the abortion, then they can be disciplined both by a professional medical society and by the state. And so these pro-life physicians really need clarity on what the law is in Mississippi, and for the courts to tell them that, in fact, the elective abortion ban that Mississippi has enacted, that's valid. You don't have to provide abortions. You're not going to, or refer patients for abortions. You're not going to get disciplined by the state if you don't.
Had we had any incidences of that, or where a mother's life was in danger because of that? And I think you have communicated with the Mississippi State Board of Medical Licensure, and of course, former guest on this program, Executive Director Dr. Kenneth Cleveland. Have you talked with him
about this case?
Yes.
No, I mean, we have not talked with him. I mean, really, we need to talk through his lawyers since we've, got a pending lawsuit here. But no, I mean, it's interesting. These professional medical societies have been pushing and really kind of reserving the right, is how I would call it, to punish physicians. And when I say professional medical societies, I don't necessarily mean the Board of Medical Licensure. The Board of Medical Licensure is authorized to punish physicians if they're punished by these professional medical societies. And these professional private medical societies are the ones that have really pushed this agenda and put pro-life physicians at risk of discipline, both by those associations and necessarily by the state.
What a weird quirk when you start thinking about it. Where Dobbs originated, of course, in Mississippi, and I'm not sure, does anybody else having problems like this in any other state?
I'm not aware.
Post Dobbs.
Yeah, I'm not aware of another state that has both. The quandary we're in. I mean, it absolutely is crazy, Paul. I mean, we're in a situation where abortion, technically speaking, is both illegal and legal at the same time, depending on whether you're looking at Mississippi laws that have been passed by the state legislature and signed by the governor, or if you're looking at an opinion of the Mississippi Supreme Court.
And then, of course, this was fodder, and it was used by the Democrats during this past election. I'm not going to get back in there and rehash the Roger Wicker interview earlier, but I mean, they used this over and over and over again. There were stories out there. Some mother almost died in Tennessee. There were several stories like this, that they couldn't get to an abortion clinic one way or the other, and then you start looking behind the scenes on this one, and most of that was not fabricated, but it was exaggerated in a lot of different ways.
Absolutely, and some of that has just been very odd to me to see play out, and some of the kind of misinformation you hear even here in Mississippi, because we've already talked about it, but the elective abortion ban in Mississippi, is very clear that it does not apply to cases where, the mother's life is in jeopardy. And so, I don't see any reason for any physician to be confused about that. But honestly, I think it's these same professional medical societies that we've already talked about that are kind of ginning up that confusion. So they should be stepping in and letting their doctors know, hey, look, the law in Mississippi allows you to do these things, but I think they're remaining silent to try to sow confusion, and it's really just a part of their pro-abortion agenda, I think.
Well, here's anything else on this subject?
Well, we've got Andy Taggart is our co-counsel on this case. Of course, he's a founding partner of the Taggart, Rhymes, and Wiggins law firm, and a very successful and prominent attorney here in Mississippi. And so we're just really glad to have him on board helping us. MJI can't litigate the cases that we do without good attorneys like Andy stepping up and helping us to do it.
Aaron, what's the timetable on this one?
Well, we just filed this yesterday, and so we haven't even received a response from the state yet. So it's really hard to say, Paul. I don't know exactly what the timeline will be, whether it will be kind of put on an expedited track or not. A lot of that depends on what the court does and how the parties litigate it.
There's an appeal process, no appeal process. I mean, as soon as the decision is made by the courts, that's the final?
It's filed in Hinds County Chancery Court right now, and it ultimately, very likely, will be appealed up to the Mississippi Supreme Court, and they're the ones that will make the final decision. There's no appeal from the Mississippi Supreme Court on this issue.
Have you guys gotten involved, or why aren't you involved in a couple of other things that I've always wondered about this? Number one is school choice. Why wouldn't that be something that you guys would get involved and put legal pressure on that? Yeah,
well, we absolutely have. I mean, you may remember that MJI intervened into a lawsuit, and we did that in order to defend Mississippi's Charter School Act. And so, and we were successful in doing that. The Southern Poverty Law Center had filed a lawsuit claiming that the Charter School Act that was passed by Mississippi was unconstitutional. It violated the state constitution. And so we represented a group of parents who sent their children two charter schools here in Mississippi, and we intervened in that lawsuit and helped defend the act, and were successful at the Mississippi Supreme Court. So I agree with you, Paul. I mean, I think school choice is an incredibly important thing here in Mississippi. I wish we had more legislative progress on that, and our policy arm, the Mississippi Center for Public Policy, is working very diligently on that issue. I honestly, it's one of our highest priorities going into this legislative session.
Well, it would seem that there would be a natural movement over to the complete school choice from the vehicle you rode in on, as far as charter is concerned. When you have, say, a single mom who lives on Oak Street and right across the street is a school that is a well-performing public school, but she happens to be drawn into a line that has to send her school or kid on a bus to an underperforming school, another public school. So she can't choose public school to public school. Seems to me that would be number one, and that would be an easy thing to win in today's climate.
Absolutely, I agree with you. I mean, one of the things that's the saddest to me is just to see children who are trapped in failing school districts.
Yes.
They can't get out of them. They don't have the money or the resources to send their kids to private school or any of that. And so I agree with you, Paul. I do think that, one of the, just like you said, kind of the easy first step to that was for us to get charter schools in the state at least, and those could open up, especially in areas that had a failing public school. But there's really been kind of just not as much progress on that front, and for a host of reasons, I think the Charter School Authorizer Board has not really worked with some of the applicants to get more charter schools open in the state, and there's a lot of other things that go into that. But I do think we need to see more progress on the charter school front, and like you said, ultimately I think we need to do more to open up schools.
Well, God bless, and I'm glad you guys are here. I have another question for you too. Can you hang on for a second?
Absolutely.
Well, you need a rest anyway from the driving experience that you had.
Exactly.
Well, I want to ask you about Blue Cross Blue Shield.
Okay.
And another thing that's hurting a lot of people in the state of Mississippi, and this UMMC, and your thoughts on that one pertaining to your directorship at the Mississippi Justice Institute, Aaron Rice. With Aaron Rice from the Justice Institute, the director, why not get involved, or is it one of those areas where there's just a no-win situation on this insurance for the in Blue Cross Blue Shield, UMMC, et cetera, et cetera? Your thoughts on that, Aaron?
Yeah, well, if you're asking if MJI would be involved, it's really a private litigation, private dispute between some private parties over financial issues, which is not really what we do. I mean, we get involved in constitutional litigation against the state. I'll say, too, I'm not an expert on this dispute by any stretch, Paul, so I don't want to give your audience the impression that I am. But I think all Mississippians who have been watching that play out, it's really an incredibly sad situation. I've talked with people who I know personally who have suffered a lot, because of this dispute and the inability for them to have insurance coverage sometimes at the only provider that can provide some kind of specialty care that they need. And so, as an attorney, you see this kind of thing a good bit where I feel like parties get so dug into their position and there's just so much animosity there that it's hard to really just get something resolved. But I think we all feel like the parties here, need to work something out for the benefit of Mississippians. Yeah. One other thing I'll say quickly, if I can, Paul, is that I think this is honestly, indicative of a much larger problem we have in the state, and something that MJI is working on, and that's our certificate of need process in the state. And so, that makes it, as you know, and we have a lawsuit trying to challenge our certificate of need laws in the state, but those make it incredibly difficult, if not impossible, to open up other hospitals, other kind of medical, professionals to provide their services. And so you wind up in situations like this where if one medical provider is having a major dispute with an insurance carrier, there's hardly anywhere else to go a lot of times. And so one thing we could do is just try to get more healthcare facilities in the state, period, and try to open up our laws to allow for that, so that we're not, for competition, so we're not in this position again.
Well, then what happens is the end user, the patient's getting caught because they've done a deal with the company through their workplace or whatever it happens to be, and all of a sudden they didn't renegotiate the contract.
Yeah.
All of a sudden what they thought they had, what they signed on to, is not there anymore, and where's the legal remedy for that as far as the individual is concerned?
Yeah.
And a lot of times it's not an inconvenience, it's life and death.
I agree with you, Paul. I mean, this is not your average dispute. I mean, this is really affecting, ordinary people here in Mississippi, people who are very vulnerable and need health care. And the fact that, this dispute between these two major, very large entities in the state, private entities in the state is just very frustrating. And I do think, I know everybody hopes that those two groups can come to a resolution on that.
What else you guys working on?
Well, I mean, like I said earlier, we're working on our certificate of need case.
Well, let me ask you about this. I was going to ask you about it. Where is that now? Because we've been talking about this for a long, long time.
We have, and this case has honestly moved very slowly. One of the reasons for that was that we had some private entities that sought to intervene in our lawsuit, and so we spent there was a lot of time back and forth early on in the case about whether they would be allowed to do that or not, and that kind of stalled the case out.
As joining with you as friends, or what?
No, as on the other side.
On the other side,
we had a group called the Mississippi Association for Home Care, who represents home care providers, existing ones, and they intervened into the suit to help the state defend the law because they kind of like it. It protects their members. But that where it is, to answer your question, we did finally get past that. After we got past that, then those groups sought to dismiss our lawsuit, and so we had to fight about that for a long time, litigate whether our lawsuit would be dismissed or not. It was not, and then we finally started litigating the actual case. So right now we're going to serve an expert report here on December 6th that's due at that time that'll lay out a lot more of the evidence that we've obtained about the effect of the certificate of need laws in the state, and then we'll just continue to litigate from there.
And this all with the story on the rural hospitals closing and all of this, and I understand it just kind of gets muddied as far as the front page is concerned sometimes. Yep. Anything else? I was just thinking there was a couple of other things that were going on. But,
well, I mean, there's a lot going on at the U.S. Supreme Court in this upcoming term. Yes. I mean, we're going to see the Harvard UNC case about racial preferences in college admissions. And, that really gets at, there's a whole kind of DEI structure at universities now that's grown up. And, I mean, that's just a huge thing. So it's going to have a big impact on higher education, I think. And, of course, Harvard and UNC are the oldest public and private institution, colleges in America. And that case involves, I mean, if you look at the statistics, I mean, it's kind of a black box in terms of how these colleges actually do, acceptance of students. I mean, how much they weight race and all of that. But if you just look at who gets in, the statistics show that it's tremendously more difficult, for example, for Asian Americans to get into those universities, and then to a lesser degree for white students to get in, for Hispanic students to get in, than it is for African Americans. And so I think that's going to be a very important case to watch. I mean, that's been going on for a very long time now. And I think, a lot of people are going to be paying a lot of close attention to that.
You know what it's like? It's a little bit like, when I'm trying to explain this on the air, like unions. Because it's hard to say there was a time in America where unions were needed. There was a time in America where we had to make some changes, where affirmative action, but they got the job done or they were outdated after that. And I think both of those are about the same way now.
It's interesting you say that, Paul, because in the case that originally allowed for that kind of affirmative action, if you want to call it that, at the higher ed level, I've never seen a U.S. Supreme Court opinion say something that's kind of offhand and odd because it has no basis in, American law or jurisprudence. But one of the justices who wrote a concurring opinion that I believe wound up kind of being the controlling opinion in the case, but wrote that, we probably need to do this for maybe about 25 years or so, and then the need will be gone. So she actually said exactly what you just said, but in a United States Supreme Court opinion. So we're not quite up to that clock of when that justice had predicted that the need for that would go away, but we're getting close to that clock, which is one of the reasons that
maybe when the medicine starts to kill you would be some kind of indication, because it's turning on Asian Americans because of the meritocracy that they've exhibited.
It is absolutely fascinating to see, and then sad to see. It's crazy to see. I mean, just like I said, I mean, you can look at how difficult it is, just statistically, just look at it, and if you're an Asian American, if you're looking at your ACT scores and all of these things, and what seems to happen is that a lot of times these universities, claim that they interview these students and they just have a bad personality and quote unquote. And so, it's quite interesting to me that these universities seem to think that pretty much every Asian American they ever interview has just a terrible personality. I mean, that's just a very sad commentary on where we are.
Without parents getting involved in their kids' education, now even more so on some of them, I'm hoping that changes with Gen Z and millennials, and I think it may be. I think we were at fault as baby boomers sometimes because we just turned it over to the educators. And now, during this period of time, certainly during social media, the things that they need to be taught and grounded, they're just not getting it. As far as patriotism, the need for bonding with America, the need for understanding the differences between communism, socialism, and capitalism, and things like that. And those things matter.
Absolutely, Paul. I mean, I've got 4 young kids at home, and I think about that a lot. And you're exactly right. I mean, I love the schools that our kids are in, but I also recognize that, it's the parents' job to instill the values in your children that you want to see them hold. And, just like you said, I mean, you can't rely on other people to do that for you.
Case in point, because now their brains are more malleable than ever before, and they were played, man. They were played by the Democrats on the student loans. They were played on some of the tenets of the Dobbs decision, and they were, because now we see that it's before one of the courts.
Yep,
a court has blocked that.
Yep.
And not to say that the administration didn't know it was going to happen, but they did get the votes.
Well, I mean, Paul, that's been one of the fascinating things to me to watch too. Is during the course of the Biden administration. I mean, MJI was involved in the vaccine mandate litigation, but you have this student loan thing too. And I'll just briefly say, I mean, it just seems like the administration doesn't really care if the laws it enacts are constitutional or not.
It is what the after effects is. Just win, baby.
Yeah.
Somebody said that. I think it was Nancy Pelosi. I'll leave you on the scary point. John Kerry's overseas on every microphone saying we need to do the same thing with climate change and the mandates that we did with COVID. That doesn't scare the hell out of you. Nothing will. Aaron, thank you, man.
Good seeing you, Paul.
Appreciate it. Safe travel.